Today we'll be analyzing English civil procedure. Well, it's going to be a similar structure to my criminal procedure, English criminal procedure class, where we won't really have the ability to go too much in depth, unfortunately, because it's a complicated issue and, we had time constraints and I felt that the vocabulary was extremely similar. So I would just be highlighting some differences. The civil procedure rules are a unified set of rules for England and Wales. I felt when I was researching this that there was many similarities between the civil procedure rule code and our recent changes that we made to our own civil procedure rules. So you have the parties sort of assisting each other, and this idea of encouraging mediation and encouraging agreements between the parties. It does stand out a little bit from American English civil procedure, and I think it would be easier to understand, but I didn't really go too much in depth with it. There was a lack of time, and it is a bit difficult to research this topic. But in broad strokes, I believe we can look at it. I think as would be a little bit easier to understand than in American civil procedure, and it does use the same terms as American procedure. You still have plaintiff, and you still have your defendant. There are still jury trials for civil cases in the United Kingdom, just like the United States. Case management is very important. Case management basically means the judge gets to decide, the deadline, things like deadlines or things like some more procedural norms. The parties can assist, but the judge has a lot of discretion what will be part of the case management. We'll look into it further, but until recently, there was a lot of the judges were expected to tolerate procedural misconduct. So if the party missed the deadline by a few days, the judges were expected to tolerate that. So they were really concerned about reaching outcomes and sort of like build a body of case law that they could use. But because litigation is much more common today, especially civil litigation, they have adopted, I think, some new rules that are more in line with international standards. So basically, settlement. This is something I forgot to mention when we were talking about American civil procedure. But you can choose to settle, and when you settle, you reach an agreement with the other part where you abandon litigation, usually for some sort of monetary compensation. So you reach an agreement, a deal. So you decided to settle out of court usually. Expert and witness evidence, the same thing. And cost. The general rule is that the unsuccessful party will be ordered to pay a successful party's costs. Again, this is something that is very easy to understand. It's identical to our system, but it's different from the American civil procedure rules, which is why I felt it was relevant to mention it. The many similarities, you file a document with the court. In the United States, you file a complaint. Here you also, the claimant also files that. These are similarities which I think are common to all civil procedure, and especially in democracies, because this is just a reflection of capitalism. You have to have a uniform and easy to understand civil procedure regulations so that trade can happen more easily. Differences, I think, the differences here are sort of the same differences that exist with American civil litigation. The most relevant difference to me is that this idea of deference to missing deadlines or procedural norms, which has been changed recently. Again, this is why it's so difficult to study English law, because it has changed a lot over the years. So a lot of the things that we associate with common English law have changed, especially over the past 20 years. A lot of the English judiciary system has been transformed. Here in the UK, similar things that I said to the UK, the US apply to the UK. So there's not a lot of specialized courts. You're not going to see a special type of judicial system just for labor relations. It's going to be everyone's going to go to the similar courts, and you're going to end up at the Supreme Court of the UK, which despite the name is nowhere near as powerful as the US Supreme Court. They don't have the power to conduct judicial review, which is something the US Supreme Court does have. So basically, they're really just a top court. They'll always defer to Parliament in terms, because parliamentary supremacy is very important in the system. Here we have Scottish. Well, we're not going to go over the specific rules of Scotland. I just wanted to highlight the fact that in Scotland, there's a bigger influence of Roman law and civil law in general. So that's something you should keep in mind. It should be easy to understand why after our English constitutional history class, because Scotland was a separate country until 1707. So they have a legal system that's very different from England and Wales. Northern Ireland, it's also got its own individual rules. I just wanted to highlight that it's also separate from England and Wales. If you want to study with Northern Ireland and you want to deal with the court system in Northern Ireland, you're going to have to basically do research specifically to that jurisdiction. And that applies to any other part of the UK, because the UK has a lot of overseas territories. There are a lot of different regulations dealing with the different parts of the UK. But in the UK, in general, it's just a very confusing mess of conflicting statutes, because the British Parliament has existed for many centuries. There are a lot of rules that even old rules. I think there's a funny criminal statute that you cannot enter Parliament with a full set of armor, or you will be executed. Obviously, that's not being enforced, but it's just still in the books because it was approved such a long time ago and it hasn't been changed. So you always have to keep that in mind. It's a complicated system that they have in the United Kingdom. The minimis non curat lex, this is the thing that I was talking about that is very different, is the idea that the law is not concerned with trivial things. So until 2009, which was when the report was written on how much this was costing to the UK judicial system, the idea was that we're not going to be concerned with trivial matters. If there's small irregularities, we're just going to overlook that so that we can actually have a trial. Here in Brazil, the opposite was true. We used to care a lot more about trivial things in the past. Now we care less, but still more than this. Because the idea especially was with deadlines. If you missed the deadline, the judge was expected to tolerate that to a certain extent. And here that has never been the case. If you miss the deadline to appeal, for instance, a certain ruling, then that's it. You can't really do anything about it. You could potentially try to argue why you did, but you have little chances of success. And that's because, we know that the judicial system is, loaded with cases, and we cannot allow everyone to just, not comply with deadlines. And that is something that they had to change about their legal system. So the report I was referring to is the Sir Rupert Jackson's report. It came out in 2009. He basically said, well, all this tolerance that we have in our judicial system to people not complying with procedural rules and case management is costing us a lot of money, and it's making our system worse. So they revamped, and that's sort of why they had that new civil procedure code, which is very similar to ours, because they're both very recent. They sort of revamped everything and tried to make things more modern and more efficient. So quicker, because that's something you're looking for with when you're dealing with civil procedure. So stricter approach. So basically, you have to comply. If the judge, when he's doing the case management, he institutes a deadline, you have to comply with it. You're not supposed to tolerate people missing deadlines anymore. Summary judgment, same thing as in the UK. You think the other party has not presented a good defense. If you're the plaintiff and you think the defendant has not provided a good claim on his own defense, you can just be, let's go to summary judgment without trial, because I think I can win this on summary judgment alone. So this is something that's interesting. They call it a satisfactory security. Basically, if the defendant, the judge can be like, I think that the plaintiff is correct and that they will in the case. So I will allow the defendant to still go to trial only if they pay a security deposit to make sure that that they won't just use the trial to put off payment, to delay the payment or to delay the penalty that the judgment is going to impose on them. This is interesting, I think, and it's a difference to other systems. Basically, confrontation. This is I believe I mentioned this in the first class. You have to be confronted. This is you have to be confronted with all the evidence against you. So this is part of the idea of discovery. There's no surprise evidence. You have to show the other party what you have. You cannot, it's not like a game of cards where you're hiding your hand. You have to tell the other party and show them all the evidence that you have so that they can respond to it. Timely witnesses. We're talking here about the compliance with procedural rules. So if your witnesses were not presented on time, then you cannot use their deposition. So basically, the compliance with procedural rules, which is something that the judicial system in the UK is now paying more attention to. This is a few things that I found when I was reading the cases. Monies, written like this, being the plural to money, and that refers to the idea of damages, compensatory damages. And then, solicitor and barrister. The solicitor is a type of lawyer in Britain and Australia who represents people out of court and in lower courts, and then the barrister would be in higher and lower courts. So it's a specialized trial attorney, the barrister. Sanctions, this is important to talk about sanctions in the judicial sense because of these procedural norms. If you don't comply with procedural norms, you get sanctions, right? So sanctions from the judge. So if you miss the deadline, you're going to get sanctioned by the judge. And you can perhaps try to apply for a relief from those sanctions. Here you can have some relevant court cases. I always say this, but please don't be limited to this. If you're going to work with English civil procedure for any reason, please go a lot. Read more case on this. Try to research textbooks. Because, like I said, even though the new procedural rules are very similar to ours, there's still significant differences to our system because it is a common law system. So yeah, this is a good starting point. It's going to learn some vocabulary, but try to look for as much information as you can. All right, so I'll see you in the next class.